Good afternoon. I'm Julia Coakley, and on behalf of the MGAA, I'd like to welcome you to our briefing this afternoon, which is being delivered by Innovation Group. Before handing over to our presenter, I'd just like to run through a few housekeeping points. Please ensure that your microphone and your camera is off, and if you'd like to ask a question, please use the chat button at the bottom of your screen. Your question will be answered during our Q&A session and will remain anonymous. However, if we don't have time to answer your question, if you provide your contact details, our presenter will be happy to answer this post-event. The MGA's programme of Learning and Insights has been accredited by the Chartered Insurance Institute for the quality of content and supporting materials, with CPD hours applicable if relevant to your ongoing professional development. The recording of this briefing will be available on our website and MGAA YouTube channel, with the PowerPoint presentation to follow post-event. Finally, you'll be sent a feedback survey. Please do take time to complete this survey. It should take no more than 2 minutes, and it really is pivotal in allowing us, the MGAA, to deliver the best quality events to our membership. So today's briefing, entitled Accident Investigations and Claims Defensibility, is being delivered by Gavin Rowell, Director of Loss Adjusting with Innovation Group Adjusting. Gavin joined Innovation Group in April 2024 as part of their strategic growth plans for their loss adjusting and claims management operations. He is an experienced loss adjuster, liability adjuster, TPA manager and operations director. With over 30 years in the industry, investigating and handling all manner of liability and property claims and managing teams of staff, including their technical audit, supervision and training. Gavin also has a proven track record in investigating and handling complex liability and property claims. In recent years, he has been directly involved in high-profile cases, including complex, life-changing injuries, allegations of modern-day slavery, bullying and harassment, breaches of GDPR, power station business interruption, and civil engineering, rip and tear claims, amongst many others. So, Gavin, if I could hand over to you.
Thanks very much. Good afternoon, everybody, and welcome to this market briefing on the importance of investigations and how these can impact claims defensibility arguments. This is a session about the appropriate procedures to adopt or for policyholders to adopt when an accident occurs. The areas I'll cover in this briefing will apply to not only, large businesses, but also small businesses, to individuals and SME type organizations. And I hope the areas that I'll cover will give you some insight into the importance of thorough incident investigations and provide some ability to feed back to your policyholders best practices that they can adopt to try and help them going forward. We were asked to set some learning objectives here by the MGAA, so we hope by the end of this presentation you'll be able to summarize to your clients the importance of the thorough investigation of accidents and incidents, hopefully be able to explain to them the pitfalls and the dangers of inadequate document completion, the failure to collect and retain the right sort of evidence, and outline how significantly the collection of information and evidence can affect a liability claim as opposed to how it may in other classes of business as well. Going to go through today why policyholders should investigate accidents. Sounds straightforward, but they need to have that sort of appreciation of what the reasoning behind our requests always are. How we can try to develop with their assistance a reporting culture, who should complete the investigations on a day-to-day basis, and then hopefully talk through a method or a best practice of completing an investigation into an incident or an accident that's occurred. And we'll try and go through the presentation with a couple of examples, real life examples of where we've seen things that have gone wrong, really, and perhaps just try and tie that into a case study at the end. So why do we investigate? There's a load of, sorry, that was one page too many. I knew I'd do that. There are a lot of reasons why we should be investigating accidents, but these are probably the four primary ones. Initially, it's a learning opportunity. If we can identify what led to an injury, an illness, an absence, or a damage event, then appropriate measures can be taken to try and prevent a reoccurrence and to improve the risk of any sort of future problems of a similar nature. There are clear legal reasons. They can include the insurance implications of repeated accidents, the risk associated with breaching a statutory duty, which could include regulatory penalties or fees for intervention, and the risks of creating a claims culture within the business where adequate steps aren't being taken. But I think probably the most important one or the most important reasons are those human reasons. At the end of the day, what we're dealing with is quite often individuals who are hurt in the workplace. So we've got obviously pain and suffering, we've got disruption to their family, to their friends, and to their colleagues, all of which can lead to issues with workforce motivation and wider social implications like strain on the health service and the like. So, it's really important that we remember that we're trying to do this for the right reasons. And then finally, the economic reasons. Whenever an accident occurs, the policyholder will suffer disruption, extra administration time, and management time. They'll have a potential effect on their reputation. That can be particularly the case in care home type industries or construction type industries where they're required to report on their claims records as part of their tenders and regular updates to their governing bodies. So these can all put massive economic strains on the business and on the economy as a whole. This diagram really just explains what we're trying to do here, because it talks about the frequency and severity of incidents. So as you can see there, we're looking at a pyramid here, which might start with, a large number of incidents and near misses, a reducing number of damage accidents or incidents, a reducing number again of minor injuries, and then, that risk of that major and sort of life-changing type injury occurring. And what we're trying to do by creating a reporting culture and creating better incident investigations and better responses to incidents is to reduce all of those numbers. So if we can reduce the number of incidents and near misses, then we'll reduce the number of damage incidents, we'll reduce the number of minor injuries, and hopefully we'll prevent any major type of injury occurring. There are always going to be accidents, but anything we can do to try and reduce that risk for the policyholder has got to be of assistance. We'd like to create a reporting culture in our clients' businesses. How do we start that risk management process? We need the policyholder to foster that reporting culture involving all of the workforce, confirming that the objective is to prevent any colleagues suffering an injury or the business suffering a loss. That it's in everybody's interest that the reporting culture is started. We need to demonstrate to them the importance of investigating properly and make sure that they're aware of the reasons why incidents and near misses, and not just injuries, need to be investigated. We need them to buy into this reporting culture. We see times when reports are completed and then they're used for disciplinary purposes. And yes, that can be a requirement at the end of the day, but it's got to be the last part of any investigation. Really, what we're trying to find out is what happened and what went wrong, if anything did go wrong, and if something did go wrong, what can we do about it? So we almost need to try and separate out that disciplinary procedure from our incident investigations. Clearly, if an employee has injured another due to blatant disregard of a process or a procedure in place, then there've got to be implications. But the workforce needs to know that they've got to report these incidents, that they will be treated in the right way, and that if required, something might occur. But essentially what we're trying to do is to protect them and to protect the businesses. If we consider who should investigate, it'll be very different in almost every circumstance. I've put on this slide just some examples of those who would commonly be involved. So the supervisor would be the person who's in direct operational control of the task that was taking place at the time that the incident occurs. their knowledge of the people, the premises, the equipment should be invaluable. So almost always they should be involved in that early part of any sort of incident investigation. Managers, again, have got to be involved. They should take charge where the actual or the potential scale of the incident exceeds the experience or the authority levels of the supervisor potentially. We do need to be careful there, because we will sometimes find during our inquiries on sites that what happens on the shop floor is very different to what the manager thinks happens on the shop floor. So they can sometimes be led by their own thoughts of how things are occurring. But certainly they're the next stage in the chain. Health and safety professionals in larger organizations are essential and will they might pick up all investigations, but they should certainly be picking up those where there are more significant injuries or where there are lessons that require to be learned. They can look at the various breaches of the regulations, and clearly insurers need to be involved as well. So, in the most serious accidents, we need our policyholders to be notifying insurers of the event as early as possible so that we have a chance to get involved. Those may be instances where the HSE have become involved, and we can, provide assistance with representation with the HSE if required. But it might be as simple as a policyholder requiring some assistance with how to complete their documentation in the right sort of way. Almost some advice on how not to shoot themselves in the foot sometimes. This is a very basic incident management flowchart. There's nothing revolutionary in here at all. I suspect this is pretty much how anybody would look to deal with an incident that's occurred. The first and foremost part is to make safe the injured person, make sure they're all right. We've got to encourage our policyholders, though, to look at the scene, to inspect the equipment, to take photographs, to quarantine the equipment that's involved, and then to start to pull together things like accident reports, statements, and complete their investigations. And they need to then review and report. So that might be to the HSE, it might be internally only, or it might be, and it should be, to insurers if the incident could give rise to a claim. If we look at how we investigate, there are some key points we need to try and stress to our policyholders. Firstly, it is investigate immediately. Inquiries don't get any easier even after a short delay. We'll quite often get told by policyholders that they didn't commence their investigations as they were waiting for the injured person's version of events. So that person might have gone straight to hospital, and they might say to us, well, we were waiting for them to come back and tell us exactly what had happened so we could complete the investigation. The problem is, if that individual is then off for a protracted period of time, we've lost the opportunity to collect the evidence there and then, that contemporaneous evidence, the evidence that's the strongest and the most influential, really. So if we can get them to start their investigations early, then we've got a much better chance of finding the evidence of what actually happened, pinpointing the cause, and potentially doing something about it. It might allow us to prevent a recurrence. So how do we investigate? We must, as I said there before, take care of the injured person first. Implement the pre-existing emergency plans, to remove the danger. Look to control any hazards and prevent any further problems arising. We must always stress to the policyholders that for the most significant injuries, they shouldn't disturb the scene. The HSE may be on their way, or the police, and they'll certainly take a very dim view if things have been changed in the intervening period. And remember to involve insurers, because they or their representatives, if it's an adjuster such as myself, they can get involved at an early stage and try to help the policyholder through this sort of situation. We generally use something that's called the 6P rule. It's not rocket science: people, positions, procedures, parts, photographs, and paper. It's very straightforward. Hopefully, though, it'll provide some guidance to your policyholders that, if they follow it, will allow them to pull together enough evidence to determine a root cause and hopefully to provide the basis of a potential legal liability defence, if there is one, or an argument of contributory negligence. So let's start with people. If possible, interview and take a statement from the injured party, but as I mentioned before, let's not delay the investigation if that individual's been removed from the scene. In addition to the injured party, though, we need the witnesses to the accident, those before the event, those after the event, and negative witnesses. So by negative witnesses, I mean individuals who immediately tell you at the time of an accident that they didn't see it. The benefit of a statement from a negative witness is that in 3 years' time, when a claim materializes and they're the friend of the injured party and they've been asked if they can provide a statement to assist them, it's very difficult for them to then change their story and say, yes, I saw it. This is exactly what happened, and it was because somebody such and such got it wrong. So, a negative statement that says, yeah, I was in the area, but I didn't see anything occur, or I didn't see the build-up, or I didn't see, the equipment fail, or whatever has happened, can be a really useful tool. There's also that requirement, though, to interview others who have some involvement in the processes that were ongoing at the time. We mentioned them before in the form of supervisors and managers, team leaders, trainers, maintenance engineers, any other specialists who might have some particular involvement in the task that was taking place when an incident or an accident occurred. Useful to speak to them and to collect their evidence at the time. If we're investigating with people, then we have to be careful of some particular pitfalls. Firstly, we've got to assess the character of the witness. We will undoubtedly come across individuals during the course of inquiries who will be all out to support the injured party for whatever reason. It might be a personal friend. They might be their union representative. There's lots of reasons why they might be, wholly supportive of the injured party, even if it's pretty clear from the circumstances that they've personally got something wrong. But you've also got to have regard to your own attitude. You can sometimes be taken down the line of thinking, oh well, this is definitely what occurred, and you're almost steering the conversation, and you've got to be really careful of that. Interviewing separately is essential. The amount of times that I've tried to take a statement from somebody when their colleague's been sitting next to them and had to say to them, look, I'm just trying to interview one of you at this time. They might want another person sitting with them, which they're perfectly entitled to have, but it's really difficult to prepare a single statement if two people are starting to chip in at the same time. So if you can interview individuals separately, you'll also get their version of events and not their colleague's version of events. That all comes down to that interviewing in an appropriate place where you've got the time, where you can relax them, where you can ask them and get them to speak freely about it. What we're trying to do is to get them to expand on the reasons that have occurred, and the use of visual aids is really helpful. I'll quite often ask a witness to sketch me out, the locations of individuals or the equipment that was involved, and if they do, then that's a really useful piece of evidence. I mean, I dread to think what they think of some of my diagrams, but hopefully those who are actually involved in the task might be a bit better than I would be. Always try to feed back at the end and thank them for their assistance, because at the end of the day, we're working towards the same goal, which is prevention of accidents and incidents, or identification of root causes. Yes, from an insurance point of view, we might be looking at whether there are grounds to defend a claim, but the reality is we don't want people hurt in the workplace either. When we investigate parts, then you'll see on here that we've mentioned examine, label, preserve the equipment, the components and the materials that might be fractured, distorted, damaged, scarred or otherwise involved. I've got a photograph there of a fairground ride, one of these, a spinning cage ride. I can't think of anything worse than going on something like that, but I dealt with the case many years ago that involved one of these rides that came off its central pin when there were 17 people involved or actually riding it at the time. And because we were able to have that central pin forensically examined and it was retained, we discovered that there was a crack right the way through that pin, and there were 14 separate layers of paint in that crack. Now, this machine was repainted every year, so the crack had been present for 14 years. The machine was also examined by non-destructive testing specialists every year as well. So for 14 years, that company had sonically tested that central pin and not picked up the crack that was developing through it. So as it was, because we'd managed to get a hold of the part that was key here, and because we were able to get it forensically examined, we were able to redirect that claim to the non-destructive testing company, and the insurer didn't pay a penny. When we look at the position of an accident, I'm not sure what this guy in this picture was doing because he doesn't look to be in very safe position, but it's really important to try and establish the position of each party and any materials and any plant or equipment relevant to each other or a fixed point. If the policyholder can be encouraged to take precise measurements, they will always help. Sketch plans in those circumstances always help. We've had lots of instances where it's difficult to understand exactly how an accident occurred because, understanding exactly where people were positioned when moving plant and equipment was proceeding through a workplace can be really difficult if somebody doesn't collect that evidence right at day one. So it's really important to try and remember to photograph the scene, to measure the scene, to establish the routes that people were traveling on, whether it be they pedestrians or equipment that was being maneuvered or whatever else. So photographs, really straightforward these days, particularly in the day and age of camera phones. The biggest problem we tend to see on a day-to-day basis is the failure to store the photographs in a place where it's going to be accessible somewhere down the line. In the ordinary course of events, if we're dealing with a personal injury claim, the claimant might have 3 years to issue proceedings, 3 years and 4 months to serve them. Now, if they submit their claim late in the day, potentially deliberately, but maybe that's me being cynical, then if somebody did take photographs, there's no guarantee that that individual's still working for the business any longer. If there is, then we quite often get a comment that says, "Oh, I think Billy took photographs on his phone, and Billy still works there." And we find him, he says, "Oh no, I haven't got those anymore. I've changed phones since." So not only should they, photograph the scene immediately, ideally using a digital, camera or phone with time and date facilities, but they should save the images in an appropriate way within the business somewhere, as opposed to on a personal phone, where anybody who's investigating at a later stage can recover that information. The other one that's really important under this heading is CCTV evidence. I think I've got a slide on that actually. Yeah, CCTV can be critical. This is a slide. It's not a real life accident, but it does bring to mind a real life investigation that I completed again quite a lot of years ago, which involved an individual who slipped on a spillage of sugar on the floor of a supermarket store. When we reviewed the initial CCTV evidence, we saw this individual walking down the aisle in the supermarket and then immediately slip and fall on what appeared to be some fairly indistinct spillage of sugar. What we did do, though, on that occasion was review further back on that footage, and about 5 minutes before that incident, he'd walked up that aisle, spilled some sugar on the floor, and then walked round into the next aisle. He then waited until a member of staff was actually following him and then walked back up the aisle and slipped on the spillage that he created. So we were able to prove in that case that this was a staged accident. So, but just remembering to actually check for CCTV, and if there is CCTV, actually retaining it is really important, and a really important message to get across to any policyholder or client, because it's the best type of evidence we can get. you've got to be really lucky for the camera to be in the right place and to catch the incident. But when it does, that evidence is brilliant. If even just to prove that it did occur. Paper is the next one. We need to be encouraging our policyholders to collect together the documentation and the evidence relating to their policies and their procedures at the time that the incident occurred. Again, if the claim comes in later in the day and an investigation is completed late, those policies and procedures might have been overwritten. And whilst we would hope that our policyholders will store and quarantine each version of their risk assessment that's developed on an annual basis, I've got to say that almost invariably they tend to overwrite the one that was before. So when that occurs, you've almost lost that opportunity of collecting the assessment that was in place at the time that the incident occurred. So we need to encourage them to pull together those management policies, the risk assessments, anything to do with the system of work that was going on at the time that the incident occurred. Installation, repair and maintenance records are essential these days, particularly these days. We had a situation where previously a breach of the provision and use of work equipment regulations, where work equipment became defective and caused injury, was held to be a breach of an absolute duty, and it was almost a case of a strict liability attaching. That civil liability has been removed, and there are now chances to defend those cases if we can show that the employer did everything that they possibly could to regularly inspect, repair and maintain the equipment. There's still difficult arguments to run, but without those records, then they're impossible. So I've also got on there things like manufacturers and suppliers data sheets. How does the manufacturer say the equipment should be used? What does the data sheet on the chemical say about how it should be used in the workplace? And then the final one on there, and again, it's very straightforward, is training records. We need the evidence to show that not only have we got all of these policies and procedures in place, but we've actually trained the staff on how to operate to those policies and procedures, to how to operate the equipment properly. So pretty all-encompassing, but that documentation is really essential, and is often referred to as the battle of the forms. And the more forms we've got to help ourselves, then the better our chances of defending cases. I'll mention a quick case here, which is one really about completion of incident documents. I've got it on there as "Don't shoot yourself in the foot." I dealt with a claim again a long time ago involving an individual who was operating a powered pedestrian pallet truck. And you can see from that photograph that the method of operating that equipment is to stand sideways and face the direction of travel. Now, the individual who operated the powered pedestrian pallet truck on that occasion managed to drive into a low-level wall on the site. And when I went to investigate that incident, I found I was met with an accident report that had been completed following an investigation, which said something along the lines of the actions taken to prevent a recurrence. We've slowed down the speed of the powered pedestrian pallet trucks. What it should really have said was, we've reminded the operator that he's got to look where he's going, because although it was a low-level wall, it was right in front of him, and had he been facing the direction of travel as required by his training, then no incident would have occurred. There was nothing wrong with the speed of the pallet truck. It was one of those cases where the individual who had completed that investigation on the site, the supervisor, was obviously keen not to criticize that individual, but it meant that we suddenly had a document that is discoverable, that we've got to give to the other side if we're trying to defend a claim, and it says on there that they've had to slow down the speed of the pallet truck, and I'm suddenly on the back foot trying to explain that, well, actually that's nothing to do with the cause of the incident. Now, we were able to do that by way of statement evidence and the like on that occasion, but they've just got to be careful not to shoot themselves in the foot, and it's a really good example of where insurance professionals, where loss adjusters and lawyers can assist policyholders in the event of particularly a more serious accident. We can help them even with the terminology and how they should complete their incident report documents. The next one, the next P on here is procedures. We're talking here really about the procedures that are in place that are both reactive and proactive. So there's obviously things that occur immediately after an incident to try and make the area safe, to try and prevent any more accidents occurring, and that proactively prevent further accidents occurring. So we need to make sure that policyholders and clients are aware that they need to allocate these tasks out to the right people and to follow them up, to make sure that they're implemented, to put in place a time frame to audit and review to make sure that they've got a chance of preventing similar incidents occurring in the future. I suppose I'll go on just to mention a case study. Really, it's probably not really a live example, but just an amalgamation of many examples of where I've seen some of these issues go wrong in the past. So we'll try and talk about a sort of practical example illustrating how we could have what appears to be a trivial incident, what might have been reported as modest injuries, but that leads to an inadequate immediate response. There's management failings after that, and there's potential financial implications as a result. So let's say we've got an employee, we'll say he or she's aged 38. They're injured when manually moving a barrel of product, such as I've found a photograph on here. That's not a live photograph from a claim, by the way. That's just a stock photograph. That individual at the time reports a twinge in the back, but they mentioned it to their supervisor, said, oh, I clipped me back there, but they make light of the injury. They say, I'm fine. No, I don't need any assistance. And yeah, I'm all right to continue on with my duties. And it's great. They're, they just go back to work. Nothing's written down. Everybody thinks, well, nothing's happened there. But a month later, that individual has a couple of weeks off with cervical spondylosis or any other one of the myriad of different back type problems that people can report. It might only be that they've reported it as a bad back. And, you go in to see your GP and say you've got a bad back, then he will sign you off if it's significant enough. A year later, that individual who did manage to come back goes off again with back pain. And this time, those issues are significant, has to go through all of the HR procedures that the employer might have in place, and eventually employment is terminated on capability grounds. This individual is not going to be able to manage what is a heavy manual task. So there was no investigation because the individual made very light of whatever happened at the time. No report documents were completed whatsoever. Nobody actually went to have a look at the equipment or the item that was being handled at the time. So we don't have any evidence of its weight, of its dimensions, of how difficult the task was. There's no photographs. There's no review of the CCTV completed. So, we don't even have any evidence to confirm that something did occur. There was an assumption of a minor incident, of a near miss almost, but because of all of that evidence, all of that information that we've talked about earlier is lost. And we've lost any opportunity of collecting that contemporaneous evidence, that evidence that was compiled at the time that the incident occurred. So 2 years, 11 months and 29 days later, so just in time, letter of claim from Sue Grabbit and Run solicitors. I spend a lot of time disagreeing with solicitors, so sorry if I become cynical on some of those comments. They allege that the injury occurred because of the excessive weight of the item that was maneuvered on that occasion. They allege negligent breaches of the manual handling operations regulations. They tell us at this point that their client, who was medically dismissed, has been unable to work since, and he's unable to work again really in a heavy manual job. He's an unskilled operative. It's going to be difficult to retrain him. And suddenly we've got a claim for, a significant loss of earnings. We've got a claim for significant care, for significant services. it could be horrendous. So we go to try and investigate that incident. The supervisor has a vague recollection of this conversation that occurred at the time, where he said that the individual had twinged his back. He might even have said it was when he was moving a barrel, but nobody went and had a look at it. There were no witnesses to the incident. There's witnesses to processes involved in that business where employees were being required to move heavy loads, perhaps working alone, and almost a condoned system of work, maybe an unsafe system of work. There's no photographs, and CCTV will long since have been wiped. Commonly, we might see it being retained for 28 days in a workplace if we're lucky. And unless somebody has the wherewithal to think, oh, this could turn into a claim, then it'll just have disappeared off the system by the time we get involved. They need to save it elsewhere, again, in the right sort of location, as we mentioned earlier. The hospital records that we'll get access to, they'll say that the individual did attend A&E that night, and in those records it'll say something very helpful to the injured person's case along the lines of hurt back at work, and it might be as simple as that, but there's some contemporaneous evidence that supports the claimant's version of events, that an incident occurred at work. We look at the GP records and the hospital records, and there's no prior history of back problems. We get orthopedic opinion, and that shows that, yes, there was a pre-existing condition, but that has been brought forward by 10 years. So we get significant general damages potential, a past loss of earnings award. We get a claim potentially for vulnerability on the open labour market, a Smith versus Manchester award, or for potentially a future loss of earnings period until retraining. We get a significant claim for care and services. There can be significant benefits. The CRU need us or require us to repay any benefits that accrue as a result of an accident. So that will include NHS charges, but then also things like, mobility benefits and the like, if they do arise from the injury that occurred. We'll have significant claimants costs and significant defendants costs. And you can see from that table there, I mean, they're not real examples, but it's really easy to get to a relatively significant sum very quickly. And that's for, an incident that's maybe not of the most severity. It could be even worse. We could find out during the course of our inquiries that the injured party is a regular claimant. The suggestion being that they know how to, how is put to me quite often, they know how to play the game. There's hints and rumours of a sports-related injury. The amount of times that I'm told, oh, he goes to the gym or she goes to the gym, and, it's bound to be, that shoulder injury is bound to have come from there. But when you try to find anybody who goes to the gym with them or who will talk about whether anything of that sort had happened, you're just met with an absolute wall of silence. Nobody will assist you in those circumstances. We look in detail, or we get our consultant or the consultant whose duty is to the court to review all of the individual's medical records, and there's nothing in there that's inconsistent with the version of events that's been put forward. We can have even more significant problems arise that, if somebody's injured and they're laid up and they're unable to work, we can have psychological problems occurring because of that, all arising from this incident. We might, if we've got some of these suspicions, this regular claimant one might be one of them, we might arrange surveillance on a discrete basis. But again, it's one of those areas where you've got to be looking at, and I'm pretty sure that, claimants will be briefed about the risk of being surveilled. So, if our surveillance fails to identify suspicious behavior, fails to find them working when we're told that they're not working, then, that's not going to help us either. So we suddenly are then faced with a guy or girl who's going to retire. I mean, we commonly look at something like 68 these days, but the reality is nobody can be forced to retire, so they can try for more. But, if they're going to retire at pension age 68, the Ogden multiplier for future losses might be as high as something like that 27.86 figure, and the £185,000 claim could be easily be a £500,000 claim or more. So the implications of not investigating what was a fairly simple and innocuous incident can be absolutely dramatic. We need to remember that the claimant's unchallenged evidence under oath is likely to be accepted. So if it's the claimant's version of events that they tripped or slipped and we can't prove that they didn't, I mean, I know we're always told that the claimant's got to prove their case, and they do. But if they say, I tripped and we can't directly disprove that, then there's a good chance that a court will accept that somebody is telling the truth that an accident did occur. Judges tend to be claimant biased. They will look at an incident or an accident and they'll undoubtedly know that there is an insurer involved if it gets that far. They see insurers as having deeper pockets, and they'll see a poor, unfortunate, injured person. I've talked a lot about employees being injured, and a lot of what I've done today is talk about accidents in the workplace. But the same goes for accidents in the street, accidents in shops, accidents in supermarkets. The judges will tend to be claimant biased. You've got to take into account that if you've got a claim that's come in from a little old lady or a child, then you're going to have some really good evidence, or the judge could just take one look at it and think, oh, reminds us of me son or my daughter, or reminds me of me grandma or my mother. So, that evidence is crucial. Pictures speak 1,000 words. If we can say, somebody said to us, oh, I tripped because there was a missing paving slab, and we've got photographs which show that there wasn't a defect or whatever, then that's really helpful. Sometimes it comes down to that identification of the position. We will get somebody who will say, I've tripped on this defect that you're responsible for. We go out to the site and we find that actually the site boundary is just on the other side of that accident location, and we're able to defend it and redirect it to the right party. So site investigations are crucial. The documents are crucial. That battle of the forms. Without them, our chances of defending claims, we're not necessarily completely without an opportunity to defend a claim if there isn't, for example, a risk assessment, because effectively what that is there's no documented risk assessment, but there will be lots of information within the business that we can collect by way of statements on how processes work and how to prevent accidents. So, if you've got it in writing, it's really helpful. And we see a lot of cases discontinued where you can supply your opponents with lots and lots of documents that say, look how good we are at managing our workforce, at training our workforce, at working out what the risks are that they're exposed to, at controlling those risks. And if we can send them all of those documents, then they might well just drop their case at an early stage. Medical experts tend to be patient orientated. I mean, that's quite simply because the only person who they get to see is the injured party. So if the injured party goes in there and tells them, I hurt myself doing this, then they will put in their report that the injured party hurt themselves doing whatever he said or she said that they did. So it's almost up to us to disprove all of these parts. The last item I've put on this slide is disclosure is mandatory. And that's the one where if I'm trying to defend a claim, then what I have to do is to provide our opponents with the evidence that I'm seeking to rely upon. So all of those incident report documents, all of those procedures are documents that they would be entitled to. So if the policyholder has shot themselves in the foot in the incident report and said they've slowed down the speed of the pedestrian pallet truck, then I'm going to have to deal with that. And we might well have just completely shot ourselves in the foot. Might not be something I can deal with in certain circumstances. In other instances, what you will find is that you'll collect the procedure documents, and the procedure documents are very different to how things actually operated in the workplace. And if that's the case, then again, effectively, what we're giving is our opponents a reason to say, well, you say in your documents that this procedure should be done in this way, but actually our client tells us it's done in this way. So you've obviously condoned an unsafe system of work. Well, both systems might be safe, but it certainly doesn't help us if we've got to try and run that sort of argument. So I think I'm 3/4 of an hour into this presentation already. So I was told to try and come up with some learning objectives as part of the presentation, and they were hopefully to be able to summarize to clients the importance of thorough investigation of accidents and incidents. Hopefully, by being able to explain to them the pitfalls and the dangers of inadequate document completion, describe to them the evidence and the importance of evidence collection and retention in a place where you can, get to it where you want to. And I think the last one says that outline how significantly liability claims differ from traditional classes of business, motor and property. They do, perhaps not motor, if you're dealing with an incident involving an RTA, although I would see in most cases when I've become involved in those, and I don't do a lot of motor work, that the evidence tends to be collected at the time. Also tends to be nobody's fault on a motor accident. Everybody thinks it was the other person's fault. But even in property claims as well, this collection and retention of evidence is essential for the policyholder and particularly for us as insurers. So that's the end of my presentation. I'm happy to take any questions now if there are any, or if any have been put up in the chat during the course of the presentation. If there aren't any, then feel free to get in touch with me directly. We find that where we can work as loss adjusters with policyholders on a regular basis, we can talk them through all of these procedures and policies that I've tried to outline today. And if there's anything that we can do to help on that sort of front, then I'd certainly be more than happy to do so. At the end of the day, it makes my life a lot easier as a claims investigator. But thank you very much for your time.
Thanks, Gavin. I've got one question for you. We've obviously got delegates on the call today. They've got varying degrees of experience and probably varying degrees of involvement in the actual claims investigation process. But if you could kind of leave our members perhaps with one piece of advice in terms of, we're all so terribly busy, calendars are busy, there's all lots of good intentions, and I'm sure all of our members believe that their claims investigation processes are running well, but there's always room for improvement. Is there one area or one thing that you would say, if there's one thing you must do, this is it? Is that possible?
Difficult. I think a former client once said to me when we were investigating an accident that it was all about evidence, evidence, evidence. And that's probably what it is, really. So no matter what you do, collect the evidence and keep a hold of it. I think that's probably the secret. So
sounds like great advice.
It's really difficult. At the end of the day, there's always an area where there's a hole in that evidence collection. But the more they can do to try and pull that information together, the better, really. And the more chances they've got to try and, well, A, prevent another accident of a similar nature if they've got something wrong, or B, actually mount a defence if they haven't got something wrong, if the individual's got something wrong. So yeah, evidence, evidence, evidence. I think
great piece of advice. Well, thank you very much, Gavin. That's really kind of you to speak to our members today and Innovation Group. We're always delighted to have our members with subject matter expertise come and share their knowledge. It's fantastic. And then to our delegates, hopefully you will be registered for our MGAA Claims Conference, which we are holding on the 7th of November at the Queen Elizabeth Centre in London. So as I say, if you're not registered, do explore that on the MGAA website under events. And just finally, please do provide your feedback on our feedback survey when we issue that, because again, it really is important to gain your opinion on what we're getting right and what perhaps we could improve on. So just leaves me to say thank you very much for joining us this afternoon. Gavin Rowell, thank you again for presenting to us. It's much appreciated. And Innovation Group, we appreciate your support. Thanks very much.